Hi, everyone. Dave Sugden of Evidence at Trial. Let's talk about hearsay. Specifically, let's talk about hearsay as it recently came up in the People versus Donald Trump et al. Case pending in New York. Now, the complaint in this case is the length of a small novel, but we can simplify it to look at the recent hearsay issue that was covered by the media with perhaps not hysteria, we'll just call it a lot of enthusiasm. Now, what the complaint alleges in this case is that Donald Trump made fraudulent statements on his financial statement of condition in order to do two things. One, induce banks to give him loans with favorable interest rates, and number two, induce insurance companies to give him insurance with high coverage and low premiums. And to understand it, let's really simplify it. Suppose that Donald Trump owned a house. Let's assume that the house had a market value of $1 million and that Donald Trump had a mortgage of $500,000 on that house. Now, what Donald Trump wants to do next is buy a condominium. And to do that, he wants to borrow $400,000 from a bank. And so what he does is he shows the value of the house, and the bank looks at this and says, okay, it's worth $1 million, and Donald Trump owes $500,000. If we use that as collateral to loan $400,000, that's a risky loan. And if we give that loan, we're going to charge a very high interest rate. And so what the complaint alleges is that Donald Trump, rather than tell the bank the house is worth $1 million, what he would do is tell the bank it was worth $5 million. And as a result, the loan seems much less risky, and he would get that loan with a lower interest rate. And what the complaint alleges is that Donald Trump and the Trump organization did this at an epic scale. And so rather than just one house, he did it for all of his properties. In addition, he would increase the value of almost every asset for his personal net worth, so that not only would he use assets to get loans, but he would personally guarantee loans using his, so the argument goes, an inflated net worth. And that takes us to the hearsay issue. And to understand that, let's first introduce a couple players. First, Patrick Berney. He was an executive within the Trump organization, and he was the witness who was on the stand when this hearsay issue came up. Number two, Alan Weiselberg. Mr. Weiselberg was the CFO of the Trump organization, and of course, Donald Trump. Now, the testimony at issue is that Mr. Berney, this is a bench trial, was on the stand, and he testified that Alan Weiselberg told me Donald likes to see it go up. And when he talks about it, Mr. Berney testified he likes it to go up, and it, I don't think refers to assets, I think it refers to net worth. And so the Trump defense team said, objection, hearsay. This statement should be stricken from the record because it's hearsay. Now let's first look at the statement. We have Mr. Berney testifying that Alan Weiselberg told him being Mr. Berney, that Donald Trump likes to see it go up, and it is his net worth. And because of this hearsay objection, dueling records were provided to the judge. First, the letter from the prosecution said the hearsay objection is wrong for a number of reasons. First, Mr. Weiselberg, he was the CFO. This is a party admission. And if it's not a party admission, it's a co-conspirator admission. And they go through this multi-page analysis as to why. In response, the Trump team says it's not a party admission because even though Mr. Weiselberg was the CFO, there's no evidence that he endorsed or adopted that statement. He's just repeating what Mr. Trump may have said. And there's actually a footnote in the letter saying, in fact, there's no record that Donald Trump ever said this. And then with respect to the co-conspirator exception, they say that doesn't apply because you haven't made the threshold showing that a conspiracy even exists. And both of these letters go down this hearsay rabbit hole about whether certain exceptions apply. But let's stop for a moment and consider the statement. We have a statement that Donald Trump likes his net worth to go up. Does that prove anything? Is there a CEO in America who doesn't like his or her net worth to go up? Do you think Jeff Bezos likes his net worth to go up? Does Tim Cook like his net worth to go up? Does someone who buys a lottery ticket, does that person want his or her net worth to go up? We see this all the time. Whenever a lawyer hears a witness attesting to what someone else said, they jump on the hearsay issue and start figuring out whether exceptions apply before first doing the threshold analysis of, is this relevant? Because again, the case involves the allegation that Donald Trump made fraudulent statements on his financial condition. Then we have a supposed statement, it's unclear if it was even made, that Donald Trump likes to see his net worth go up. If you're on the Trump team, what you want to be arguing is, this isn't hearsay, it's not even relevant. Because the fact that Mr. Trump likes his net worth to go up isn't probative that he committed fraud. What's interesting is that the prosecution sort of touched on this statement in their first letter where they wrote to the judge, they said, the court need not decide the specific purposes for which Mr. Bernie's statements are admissible at this stage because the court is presumed to be able to sift through the evidentiary record and consider only proper evidence in rendering a determination at the conclusion of trial based on the entire record. And they cite a Dondre case. The Trump team responds and says, you're reading the Dondre case wrong. And whether the Dondre case stands for that proposition or not, you as the prosecution never want to make that argument. No litigant ever wants to go to a judge and say, it's not up to us to decide what's relevant. We're going to give you a bunch of information and let you sift through the record to decide what is relevant or not. Instead, you as the proponent have to explain why it's relevant, and if you're opposing it, explain why it's not. And so there it is, hearsay in the Trump case. Folks, I hope this was helpful. If it was, please like, subscribe to our YouTube channel. If you want a topic covered, leave a comment. If you want to do a really deep dive on these evidentiary issues, check out our online course page at evidenceattrial.com. Thanks for watching.